This tutorial is designed to help you recognize the structure of an Old Bailey trial report, to identify the difference between the formulaic language used to record the legal process and the testimony presented to the court that purported to describe behavior beyond the courtroom. Exploring a single case helps to isolate the different components that you are likely to encounter when reading a trial. This is the trial of Richard Collins, who was tried for theft at the sessions of the court beginning 30 October 1793. Sessions normally lasted 3 days, so we cannot know whether this trial was actually heard on the 30th of October or a subsequent day. When read as a single trial, the original text is preceded by a yellow header box. The information in this box reflects a modern description of the trial assigned as part of creating this website. It includes a unique reference number, standardized indications of the offense, verdict, and punishment, and links to a database of related materials. The transcription of the original text begins directly below this yellow header section. In this instance, the trial begins 676, Richard Collins. The number 676 in this instance is part of an annual series. From December 1738, each trial during the mayoral year was numbered consecutively. The next element of the trial is the name of the defendant, in this instance Richard Collins. By the 1790s, the spelling of most names had become largely standardized, but for most of the 17th and 18th centuries there could be wide variations in spellings of specific names, both between and within trials. Although the proceedings contain 197,000 trials, it names over 253,000 defendants, reflecting the extent to which multiple defendants were frequently tried in the same trial. The rest of the first paragraph of this and most trials is taken up with the legal details of the case, probably read aloud in court directly from the formal indictment produced by the grand jury prior to the trial. This paragraph will normally describe the nature of the crime, its date, the item stolen if it was a theft, or the nature of assault or murder if it was an offense against the peace, along with the name and frequently, though not in this instance, the occupation and residence of the victim. This pattern of recording legal details in a separate paragraph at the start of the trial report became commonplace from the early 1720s for longer trials, but was never universal. From the second paragraph or sentence for early and shorter trials, the text takes the form of statements of evidence. In early trials, this is largely given in the third person, but from the 1710s, and more commonly from the 1730s, evidence is generally recounted in the first person and bears the characteristics of spoken language. Whose spoken language is recorded, and how close that language was to the words expressed in court, is a different matter. Much of what was said in court was not reported in the proceedings. In the case of the trial of Richard Collins, the second paragraph simply states Joseph Stevenant sworn, followed by a first-person statement providing information about Joseph Stevenant's identity and giving basic details of the crime. The language recorded appears to be a verbatim statement, judging by the repeated inclusion of the first-person pronoun I, but it is clear that some speech was excised as dull and repetitive, or else transformed into a more readable form for publication. Joseph Stevenant's statement is then followed by a series of paragraphs appearing to reflect an ongoing dialogue in court, with a cue followed by a question, and an answer from the witness. While the text of the question is provided in this and other trials of this time, it is omitted from reports in other years, with only the witness's answers being provided. Although the questioner is occasionally identified, he is not in this trial, as was frequently the case. Beginning in 1785, evidence that was thought to present a moral danger to the reading public was excluded. In particular, witness statements in cases of rape and sodomy were not reported after this date. The number of witnesses and the length and nature of their evidence varied widely from trial to trial, but witnesses were normally called in a specific order, with the victim and key prosecution witnesses called first, followed by those speaking to the defense, and finally witnesses to the character of the defendant. Character witnesses are particularly prominent in 18th century trials, but their evidence is less fully reported than that of other types of witness. The trial usually concludes with a statement from the defendant, normally identified as the prisoner, when they were expected to respond to the evidence against them and demonstrate their innocence. The final lines of the trial begin with the verdict. From January 1789 onwards, the age of defendants found guilty is recorded as part of this line, which is then followed by the punishment sentence, either on the same line or below. A recommendation for mercy from the jury is also sometimes recorded at this point, and from December 1775 the jury and judge who heard the case are specified here. The trial accounts published in the proceedings were edited and truncated in ways that served a number of different purposes and which changed over time. For a more detailed analysis of the changing nature of the proceedings, see the Publishing History of the Proceedings.